So what is law? प्यार क्या है? Yeah, that was correct. You said that it's a set of rules, right? So law is basically a body of principles, rules, कुछ भी बोल दो, recognized and applied by the state. So the state says कि if you have to drive on the left side, then the Motor Vehicle Act will say, we are left side and drive it and don't drive on the right side. So it's a body of rule. There is no at times no logic for why only left side, but one side is, we know there has to be a logic for one side. You get what I am saying? In India we drive on the left side, go to US you will see they are driving on the right side, right? So you have to drive on one side to prevent accidents, and everybody has to drive on the same side, right? If you are driving this way, you drive on the left side, if you are driving that way, you drive on their left side, right? So Holland says law is basically general rule of external behavior enforced by a sovereign political authority. We can keep talking about the definitions of laws, but I am a very interesting person, as you know already, right? And so I won't bore you with theoretical stuffs. I'll just give you something to read, you read it on your own and do it, right? I'll not bore you in class, yeah? So there are many different other definitions by different authors, but who are we? We are managers. We are future CEOs, CFOs, CXOs, CMOs, CIOs, whatever, right? So we will look at law, but from a managerial perspective, right? We don't end from a Bollywood perspective, just to keep things interesting, right? So we will look at law from a managerial perspective and not as lawyers, right? चलो, I have not, अभी तक कोई joke नहीं बोला ना मैंने, तो चलो एक joke हो जाए, हैं? तो पहले इसको पढ़ो. So what's happening? The residents of heaven, Swarg, and the residents of hell, Nark, were fighting, right? Swarg were very good people, nice people, reasonable people. The residents of Nark were all very aggressive, quarrelsome, not listening, nothing. So they were very unreasonable, very aggressive. कि ना जो मैंने बोला वो, they are not willing to listen. So Swarg people were tired and fed up of them. They said, we will file a case against you. So what did the Nark people say? Like, how will you file a case? All the lawyers are in hell. So you know my destiny, right? I am a lawyer. So does anyone know the 3 new laws that became effective on 1st of July? It's a very recent scenario, right? So IPC was replaced by Bharatiya Nyaya Sanhita. Indian Penal Code was replaced by Bharatiya Nyaya Sanhita. Code of Criminal Procedure was replaced with Bharatiya Nagrik Suraksha Sanhita, and Indian Evidence Act was replaced with Bharatiya Sakshya Adhiniyam, right? And do you know how old? So Indian Penal Code basically says you can't do criminal acts, right? So what's your name?
Shubham.
Shubham.
Yes.
So Shubham is not allowed to murder anyone. Sorry, huh? He is not the kind of person who will murder anyways, but Shubham is not allowed to murder also. What happens if he murders anyone? He goes to jail, right? So, and why will he go to jail? Because Indian Penal Code has provisions. If you have seen Hindi movies, आपको ये अदालत दफ़ा 302 के तहत 14 साल की कैद की सज़ा देती है. You have seen Hindi movies? So that's coming under Indian Penal Code. And Code of Criminal Procedure was basically talking about what is the process to be followed in administering the justice. So once he murders someone, police will catch hold of him, then what is the process to be followed by police? How will they file a charge sheet? Then it will go to a court. Court will, of course it will go to court immediately then, but the court will wait for police to file a charge sheet, and the court will follow a certain principle and process to administer justice. Because even if he has killed anyone, he will still get a chance to defend himself, yeah. So all those things are contained under Code of Criminal Procedure. And finally is the Indian Evidence Act, which basically says that how old is the Indian Evidence Act? Does anyone know? Take a guess. British's time. How old? That's the question. 200 was a good guess, yeah. 80 ना, 80 तो कुछ भी नहीं, इंडिपेंडेंस को 75 years हो गए. 1872. So Indian Evidence Act was framed in 1872, more than 150 years back. So now it's 152 years later, we have decided to change the act, which is making sense, right? Can we make a law in the 19th century? Will it be relevant for the 21st century? Are you getting the point?
Yes.
Over time, of course, this is true that over time they have revised it, but the body of the crux of the law is still coming from 1872, right? So that's the reason there was a need to change this. Yeah, next. And why are laws needed? To maintain law and order, to protect people, to have way of living in the society and all that, right? You all know that. But let's play a small little YouTube video. बहुत देर हो गई.
I'm just as hungry as ever. And this is cold. And I'm quite sleepy. How about if we make up our own room? Just a few important rights to help us live together without fighting. And we don't have to follow them. Not like the king, who didn't have to follow his rules. So the three friends talked it over and decided about the rules. No eating apples from someone else's tree. No making fire near somebody else's house. No keeping people awake with noisy snoring. Everybody could still do what he wanted, as long as it wasn't bad for someone else. Today, people who live together make rules which everyone has to follow. These are called laws. There are laws about crossing streets, about driving cars, about public cleaning, about stealing, and about many other things. People cannot live together without good safety laws. That's what Shiver, Gobble, and Snore found out once upon a time when they tried to live with no rules at all.
So you have understood the issue, right? So if there are no rules, then also we are in trouble. If there are excessive rules, then also we are in trouble, right? So basically it's about, we should have rules, but moderate, and the basic principle is we should not, we want our individual liberty, but not at the cost of causing inconvenience to others. That is the essence. So we have to be responsible citizens of society, and that is why laws are needed. Is that clear? Anyone? Yeah, sure. So what are the different schools of law or different ideologies of law? So there are like 5 major ideologies: the natural school, the positivistic school, the historical school, the sociological school, and the realistic. So these are like 5 different, let us say, schools or viewpoints of law. So the natural school, what is natural school of law? They are basically saying that laws are command of God, and law arises out of morality. Laws are command of God, and law arises out of morality. So whatever is moral or ethical should be the law, should be legal. If it is immoral or unethical, then it should not be a part of, should not be done. So then that becomes illegal, right? So natural school is saying that law and morality are deeply connected, and laws are command of God. Laws are not made by any authority, it is provided by nature or from God itself. Laws are divine in nature and are defined by morality. Examples, some examples are given here. We have given 3 examples. Article 14 of Constitution of India, what does it say? Equality before law. Everyone is equal before law and is entitled to equal protection of law, right? So in the eyes of law, you are equal. It does not matter what is your religion, what is your personal belief, what is whatever. Every single human being is equal in the eyes of law, right? We as human beings, we are equal in the eyes of law, and therefore we should get equal protection of the law. So everyone, ऐसा नहीं है कि he is the MLA or MP, so the MLA or MP will get a little bit more favor. Unfortunately, that happens in society is a separate issue. That is flawed implementation of law. If somebody is an MLA or an MP and the person gets some extra privileges, that is a flawed implementation of law. As per the Indian Constitution, everybody is equal in the eyes of law. Article, that is Article 14. Article 21 is right to life and personal liberty. Shubham? Yes. Yeah, Shubham. So, just as you want to live happily and freely, everyone else is also entitled to do that. Yes. You get that? Yes. So, you are not allowed to murder anyone, huh? Yes. Because you will be taking away their right to life. Yeah? He is not that kind of a person. Yeah? I am just picking upon him because I like you. Huh? Thank you, sir. Yeah. So Shubham will not kill anyone or murder anyone because he is fully aware that the other person also has a right to life and liberty. Because if he murders anyone, he takes away the life of someone. So he will not indulge in any such criminal act. Yeah. Then there is article, because we also say na कि life was given by God, right? कि ये तो भगवान की देन है, अल्लाह की देन है, जीसस की देन है, right? So life is given by God, and therefore we will not take anyone's life. So what does Article 19 say? Everyone should have freedom of speech, expression, belief, faith and worship, right? So you can say whatever you want without causing trouble. You know, there are limits of freedom of speech. कि ठीक है, if you want to protest, you protest in a reasonable manner, but you can't protest and jam all the streets and create inconvenience to others. You might have seen there were some Supreme Court said कि भैया आप लोगों ने तो पूरा रास्ता ही बंद कर दिया है, right? Farmers and all, so they had to be, all the protests had to be shifted to reasonable places. Then you have a right to protest. You have a right to protest, but don't inconvenience others in the process of protesting, right? So freedom to assemble, we are allowed to assemble, right? We are allowed to form associations, unions and societies. We are free to move anywhere in any part of India. We are free to move and reside there, any part of India. We have a freedom of profession, we can practice any trade or profession, right? So these are all laws that seem so natural, right? Are you getting the point? कि हाँ ये तो होना ही चाहिए था, it should have happened like that only, right? So that's because they are like, the natural school is basically saying that laws are command of God and are defined by morality, and these appeal to everyone, right? Everyone should be equal. The positive school is opposite of the natural school. Natural school was saying laws are created by God, are basically anything that is moral should be law. The natural school is saying, the positive school is saying laws are made by man. So these are man-made, and you must do that, and if you don't do it, then there will be some penalty for not doing it. The penalty we will discuss in one of the later slides. So if you do it, you are anyway supposed to do it. If you don't do it, you will face the consequences of not doing anything that was supposed to be done. Motor Vehicles Act. Examples? Motor Vehicles Act. In India, as we were just saying, you are supposed to drive on the left side. In the US, you don't have to drive on the left side, you have to drive on the right side. So India decided, this is a man-made law. God never said that you have to drive on the left side or the right side, right? God never said you have to drive on the left side or the right side, but countries or people decided that yes, in India we say let's drive on the left side, in the US they say let's drive on the right side, but you still drive only on one side, because if everyone drives in different directions, then we will have lots of accidents and traffic jams. Again, in Motor Vehicles Act, if police have put a no entry sign or a no parking sign, and if you still enter that street, or if you park where the police or the local authorities have put up no parking sign, what will they do? They will fine you, right? So you will be fined 10,000 rupees or whatever is the appropriate fine of that local area, right? Trespassing. Can anyone from outside, okay, you are students, but can anyone from outside enter IIM Sirmaur just like that? No. And if anyone does it, of course the security will stop in the first place, but anyone breaches security and still does it, at some point we will call the police, right? So that you have trespassed into our territory, you are not supposed to come to our place unnecessarily. Students, faculty, staff and others can come. General public can also come for making inquiries, but not with any bad intention, you know. Are you getting the point? So trespassing is like entering into someone else's territory with some bad intention, right? You can always knock on your neighbor's door ki bhai, I am new. That's not trespassing, right? That's like social mixing. But trespassing is jabardasti ghus gaye ki hum to aayenge. That is trespassing. There is reservation for economically weaker sections. So if people belong to economically weaker sections, they need to be uplifted. That's a responsibility we all face as a society. So reservation for EWS is a man-made law, but it makes sense to everyone that yes, they should be supported. If you are poor, society and everyone should support you. Yes. The historical school of law is basically saying that laws, this is part of natural law, but it says that law is outcome of years of historical development. So, law is a result of past forces and past influences. So, social customs are sources of law, and law is formed by people and not by some divine origin. Law can be made to prohibit the social customs also. For example, if in a society, if there is a custom which people are following for more than, if there is some practice which is being followed for more than 20 years by everyone, then we can say it is customary, or then that becomes in some ways customary law can also be a law. That सब ऐसे ही करते हैं, it is customary, so it is legal. Examples, this was originally Saptpadi. In Hindu society you have seen bride and the groom, वो 7 फेरे लेंगे, right, which is called as Saptpadi. So, as part of law, section 7 of Hindu Marriage Act, when two people have taken 7 फेरे, then they are officially married. Even if they are not applied to the legal authorities for their marriage, officially marriage हो गया है, they need to register their marriage as a separate issue. But even if it is not registered, courts will still say कि हाँ ये तो husband wife हो गए. Are you getting that? Same thing, while some customs can become law just like this, some other customs, for example sati, if you know, all of you have watched many movies. So, pardon?
If the husband dies, the woman is
Yeah. So, she has to burn herself, jump in a fire. So, that was a practice during medieval times, you remember that? But this practice, we will not enter that territory why it was done in the medieval times or not, but it will not, it has no place in the 21st century. In the 21st century, women are anyways independent, growing. So, this practice has no place in the 21st century, and you would not believe it, the Prevention of Sati Act, there was no such act till 1987. In mid 1980s, a lady was forced to become a sati, and therefore, by local villagers. So, the government passed a Prevention of Sati Act that no women can be forced to burn herself with the dead body of her husband, and she has a right to life, because Prevention of Sati Act. So, she has a right to life, and no panchayat or no social person or nobody in society has a right to take somebody else's life. Right. What does the sociological school of law say? The sociological school of law says that laws are made for the benefit of society. So, law and society are related to each other, and what is the main source of law? Society. They will take affirmative actions to fill the issues and concerns arising out of any topic. What does affirmative action mean? If you know, in the US it is a very big topic. Affirmative action, if you see any US related document, you will say they will talk, we take affirmative action very, very seriously. So, affirmative action is a policy in which an individual's color, race, sex, religion or national origin are taken into account to increase opportunities provided to an underrepresented part of society. So, for example, in the US, they have this affirmative action policies which says they traditionally they are the minorities, minority community is basically the black community there, and they have been subjected to years of torture and let us say discrimination. So, they are now trying to rectify that situation by saying that okay, we will provide them additional opportunities. For example, in Indian society, we all know that women were traditionally locked in house, traditionally, right. 50 to 100 years back, we did not see any women in the corporate sector, for example, because they were in households. But in the last few decades, women have got more opportunities, and they are able to fulfill their professional dreams. That if you have a dream, at least we are happy to see so many females in the class. Let's clap for all the females in the class. So, women are at least, you see more of female students in IIMs, you see more of females in the corporate sector, and in 2013 Companies Act, they came up with a new clause or a new rule which said, that was section 149 of Companies Act, which said that we need at least one women director on the board of every company. Earlier there was no such rule. So, India became one of the first countries in the world, one of the first, not the first, to implement this rule that we need at least one women director for every company. And now there is talk that we need more than one, maybe we need minimum 2 women directors. So, this is just one example where traditionally women who were asked to do household work now have opportunities to work in the corporate sector and generally. Yeah. There was another act which is section 377 of IPC, and again that was about homosexuality was considered as a criminal offence, but section 377 of IPC has made it a that at least there is it's not a criminal offence to be homosexual, right. What is the realistic school of law? So, realistic school of law is basically saying that judges make laws and interpret laws, and the truth is judges do not make laws, but what they do is they decide cases, and in India one is of course the act itself, and these case laws also become judicial precedents and therefore decisions to be followed in future. So, the realistic school is basically saying there are 2 fields in which judges play a role in creating laws, one in developing the law and second in interpreting the statutes. So, laws are made, see the truth is judges do not make laws, but judges interpret law, and in the process they may create a law in the form of a case law, right, and we will see lots of case laws from tomorrow onwards. So, what is the doctrine of precedent? Yeah, let us also first give me hold on. Let me, Supreme Court generally will not make laws, you know that, right. Who will make laws? The Parliament will make laws, the MLAs will the MPs will make laws for centre, MLAs of a state will make laws pertaining to that particular state, right. So, Supreme Court's role is to interpret the law and deliver justice. When I say Supreme Court, that is also true for high courts and lower level courts, right. So, what had happened? So, in this, what was the case of Visakha versus state of Rajasthan? So, Visakha versus state of Rajasthan is basically a case of a government officer Bhavri Devi who was trying to prevent child marriages, and the feudal landlords in the area were like, who are you to tell us ki child marriage hona chahiye ki nahi hona chahiye, right. So, unfortunately for her, she was brutally raped even though she was a government officer trying to prevent a local authority officer trying to prevent child marriage. So, these feudal landlords raped her and she did not get justice from even Rajasthan High Court, and they were allowed to go scot free. So, many women's organizations then approached the Supreme Court of India that justice has not been delivered and now you need to deliver justice. So, Supreme Court of India usually will not make laws, but in this particular case what they did was they came up with something called as Visakha case guidelines or Vishakha guidelines, and Vishakha guidelines are all about prevention of sexual harassment at workplace, that how can we prevent women from being sexually harassed at workplace, right. So, that is the Vishakha guidelines. The Supreme Court gave the guidelines I think in 1997, and then the Supreme Court said that till such advised the government ki now you make a proper law for this topic, prevention of sexual harassment. So, the government made a law called Prevention of Sexual Harassment, it is called, in short it is called as POSH Act, but it took the government 16 years to make the law. So, even though Supreme Court gave the decision in 1997, the act came in 2013, 16 years later. So, till such time whatever were the Vishakha guidelines as given by Supreme Court of India continued to remain as law. And the truth is, those guidelines were also the crux of what is contained in the post-related regulations, right. So, anyways, so what happened was, the new act was formed. So, what is the doctrine of precedent or stare decisis? This is basically, there is an article of Supreme Court, article of Constitution of India called Article 141 of Article 141 of the Constitution, and which says that all the decisions of Supreme Court of India are binding on all courts within the territory of India. So, if Supreme Court of India has said something, whether you are a resident of Bombay or Calcutta or Delhi or Madras or wherever, or Bangalore or any part of India, east, west, north, south, you have to follow the decision of Supreme Court of India. And in India, we have, it's coming in one of the later slides, we come under the common law system of the British. So, where basically in addition to the law, we will have case laws, that in that particular case, in that particular year, the Supreme Court or some high court within India said this thing, that this is how they have interpreted the law, right. So, if Supreme Court has interpreted the law in a particular manner, all the high courts are bound to ignore their own conflicting judgments, if any, and follow the judgment of the Supreme Court of India. And similarly, if let us say you are from, who is from West Bengal here? Yeah, which part of West Bengal? Howrah and Kolkata, twin towns anyways, yeah. So, let us say Calcutta City Civil Court or Calcutta some Alipur Court has decided something. So, where shall we go if, when the lower level court has decided and you are not happy with their decision? Who will you approach? Calcutta High Court. Let us say you are not still happy with Calcutta High Court decision, where will you go? Supreme Court, right. So, stare decisis or doctrine of precedent says, if High Court of Calcutta has said something, if something happens in Bombay for example, they can consider the views of High Court of Calcutta, but they are not bound by it. They can consider the views of High Court of Calcutta, but they are not bound by it. But if Supreme Court has said something, then all high courts in India will have to follow the decision of Supreme Court of India. So, the Supreme Court under Article 147, the law or the decisions of Supreme Court are binding on all courts within all territories. But if a High Court of India of Calcutta has said something, then all districts in West Bengal must follow that decision, must. If it is a High Court of Bombay decision, it is still applicable to all of Maharashtra. Are you getting it? But not binding on Calcutta. Calcutta judge can come up with a conflicting decision. But if a High Court of Calcutta has said something, the Calcutta judge must follow the decision of Calcutta High Court. Are you all clear on that? So, that is the doctrine of precedent or stare. Precedence means this is how it was decided in that particular case. So, it becomes a case law, and stare decisis is also a same thing, that the prior decision must be given due consideration and it must be followed, not just be given due consideration, it must be followed, right. Yeah. We will not talk, we have already spoken about the 5 schools of law, that laws are like a command of God from one perspective, it is a command of king from another perspective, it is a science in itself and it is a philosophy, so and made by jurists. So, we have already considered it. So, we already know different perspectives of law. So, I am not. What are the major legal systems globally? The major legal systems globally are common law, civil law, the major ones, and Islamic law. Common law, what is common law? Common law, see, in the 19th century and the 20th century, half of the world was under British occupation. We all know that. Another 30-40% of the world was under French occupation, right. So, in the 19th and the 20th century, the Britishers and the French were had conquered a huge chunk of this planet. So, the British based law is called as common law, where they have all these acts and judicial precedents, right. and India is also a common law country. And the French based law, these are like codes, right? They don't have like cases and all. जो उसमें लिखा है वही. So these are codes and they are called as civil law. So the common law countries are Britain, India, and Australia, New Zealand, Canada, whatever you see as Commonwealth, you see that? So these are all common law countries, and that's the reason these are like Commonwealth is there, right? Then we have the civil law, which is French based laws, and there are some other, like Germany is also civil, and there is a very small proportion of countries following the there are some Scandinavian countries following their own set of things, but there are very few of them. So, and then the third category of major law is the Islamic law. We all know that Islam is a very prominent religion globally, right? So, Islamic law is there in many countries of Africa and Asia also, right, primarily. So, Islamic law is basically what's called as, say, following Shariat, right. So, you follow the rules of Islam and live accordingly. So, in many countries globally they follow the Islamic law, and because there are like 75 to 80 countries under Organization of Islamic Countries. So, there are lots of, especially a lot of African countries and Middle Eastern countries are following Islamic law or close to that. Yeah. So, India is a common law based country, and we have separation of powers. So, we have a legislature, we have an executive, and we have a judiciary. So, what is legislature? Legislature is your parliament, right. So, we will have MLAs and MPs. So, MPs will make central laws and MLAs will make the state related laws, right. Then we have executive, which is these, say, government, high ranking government officers. So, say let us say many IAS officers, they are basically, and their teams are basically responsible for implementation of law. So, legislature will make the law, while executive will implement the law. There was a fly, sorry. So, the legislature will make the law and executive will implement the law. And then there is judiciary, whose role is to interpret the law. Judiciary's role is not to make the law, that is the role of MLAs and MPs, right. Judiciary's role is to interpret the law. But as we just saw, in some cases Supreme Court can come up with, as in the case of Visakha guidelines, their own set of guidelines which become law, right. So, we have already spoken about it. What are the sources of law? Religion, customs, practices, civil law, and judicial precedents. We have already spoken about case laws, that is judicial precedents, but within that, there are two terms you will see: ratio decidendi and obiter dicta. What is ratio decidendi? Anyone knows what is ratio? It is in short called as ratio. Anyone knows? Not mathematical ratios and proportions. So, when the Supreme Court of India, for example, decides a case, it will decide a case based on so many facts and laws. Then it will say that this is our decision, and these are the major reasons why we have arrived at this decision. These are the major reasons why we have arrived at this decision, right. So, in that case what will happen is, the major reasons are the heart and soul of the judgment. The heart and the soul of the judgment is the ratio of the case, ratio. And in arriving at the judgment, they may also pass some side remarks. कि एक side issue था, ठीक है ना. So, side issue में कुछ भी हो सकता है ना, like small little things on the side, not the heart and soul. It's like something in the passing. कि while deciding this, we also said, I was not satisfied with the lighting, so I said कि अरे वो light का switches थोड़ा बाहर करवा लेना. But my heart and soul of everything that I said was कि अपने projectors को ठीक करो, audio visual systems को ठीक करो. Lighting is also important, by the way. You got the point, na? So, कि AC भी ठीक करा देना if possible. Huh? So, these are like obiter dicta कि हाँ AC भी ठीक करा देना. Precedent we have already discussed. Doctrine of precedent, article 141 stare decisis. So, we can ignore. So, the structure of courts basically is So, Supreme Court is, the jurisdiction of Supreme Court is pan India, right? Pan India means all over India. So, what is the adjudicative jurisdiction? That is the territorial jurisdiction. It means, what is the original jurisdiction? That is specified in Article 32. See, I have a fight with him. I owe him 100, he owes me, why should I owe him? You owe me 100 rupees. So, he owes me 100 rupees, he is not giving me. ठीक है? So, मैं बोल रहा हूँ भैया पैसे दो, नहीं देता. So, I go to court. Can I approach Supreme Court of India saying कि इसने मेरे 100 रुपए नहीं दिए? Right? You, what was your name? Harsh. Harsh. Don't get scared. Yeah? So, Harsh has been illegally detained by police. Illegally. Harsh has been illegally detained by police. Let's say he is from Calcutta, just for the sake of example. So, he can approach the lower level courts in Calcutta, but for illegal detention, is this a violation of his fundamental right? Right to life and liberty. Right to life and liberty. It is a violation of his fundamental right. So, the moment his fundamental right is violated, of course, he can approach the local courts in Calcutta, but he also has the power to approach Calcutta High Court under Article 226 of Constitution of India, and also has the right to directly approach Supreme Court of India under Article 32. What will he say? I have been illegally detained. My fundamental right has been violated. Therefore, I am approaching you for restoration of my fundamental rights. Constitution of India guarantees me my fundamental rights, right? Constitution of India guarantees me my fundamental rights. So, he has the right to approach the local courts in Calcutta, but he also has the right to approach the Calcutta High Court under Article 226, and he also has the right to approach Supreme Court of India under Article 32. And the Supreme Court or the High Court can issue what is called as, in such cases, the Article 32 and Article 226, they can issue what is something called as writs. So, there are like 5 types of writs, and at this point we will not talk about the 5 writs, but in this particular case I will give you some material on the 5 writs. So, you do not feel that I wanted to learn and I was deprived by Professor P. Sanjay from learning. I never let that happen. I will give you enough reading materials, and so and you are free to read the book also. Book मिल गई क्या सबको? हाँ, अरे, yeah, start reading the book. Wow. So, so what he can do is he can approach all 3 levels of courts in India, saying, and they can issue something, a writ of habeas corpus. What is the writ of habeas corpus? Produce the body before us. Produce the body before us. The police does not have the power to, if he has done anything wrong, police can detain him for 24 hours, but they, within 24 hours they can, after detaining, they must produce him before a court of law, and the court of law will then decide whether it was legal to detain him or not, right. So, produce the body. The habeas corpus writ is basically produce the body. Who are you? Who is police to decide whether any individual citizen's freedom can be curtailed or not? We will decide. If he has done anything criminal, yes, you can detain him, but without any reason you can't be detained. Yeah. So, that was the original jurisdiction. Of course, we also have, as we were just discussing, that if so he had taken my 100 rupees, right. So, first I will approach the lower courts, then for for 100 rupees we also have a court of small causes, small claims, ऐसे courts हैं where you will go for such small little topics, because they will also कि यार हमारा time क्यों खराब कर रहे हो, इसने 100 रुपए नहीं भी दिया आपके, why waste our time? Are you getting the point? Of course, I can sue him, yeah. So, don't think you can run away with my 100 rupees. So, I will sue you. So, but the courts will say कि for small little petty claims they have made a separate court कि आपस में select लो. They will keep saying कि आपस में select लो, ठीक है. And so that is the appellate authority of High Court of India and the Supreme Court of India. So, okay, fine. So, there are two types of liabilities, let us talk about that, the civil liabilities and the criminal liabilities. So, civil liability so there are two types of liabilities, one is the civil liability where a person will be awarded compensation against the loss suffered by the aggrieved party because of breach of contract, yeah. And the second is a criminal liability, which is offence against the state by performance of prohibited act, and in that for prohibited acts we will consider something called as mens rea and actus reus. What is mens rea, anyone? BCom वाले को तो आता ही होगा. What is mens rea? यार BCom वालों को तो आना था. अरे I encourage all the Rahuls to speak please. राहुल, कहाँ है मेरा राहुल? ठीक है. So mens rea is guilty mind or criminal intention. Guilty mind or criminal intention. Shubham, he is a good person, we all know that, right? So Shubham was at home at night. A gang of robbers broke into his home. A gang of robbers broke into his home. He had a pistol with him. And the robbers were about to shoot him. They were saying they were about to shoot him, right? And in self-defense, not otherwise, since he had a pistol in his pocket, they were about to shoot him. He took out the pistol and killed both the robbers. If he had killed two people, generally, that would be an offence, criminal act. But in this particular case, he can say, yes, the act is the same. I have killed two people, two robbers have been killed. So there is an actus reus, which is criminal act. There is a criminal act. He has killed two people, but he will tell the courts of law that there was a criminal act, actus reus, but there was no mens rea, there was no guilty mind or a criminal mind. He will say, I was acting purely in self-defense. If I had not killed the robbers would have killed me. So he will take the plea of mens rea, saying there was no mens rea in this case, I was only acting in self-defense and therefore I am not guilty. And the courts will also agree, right? So, and so for criminal acts, you can get either an imprisonment, 1 to 14 years, whatever, even that one also, फांसी की सजा. ये अदालत आपको दफ़ा 302 के तहत क्या बोलते हैं, फांसी की सजा सुनाती है, right? And there can be a pecuniary this thing also. What is that? You will be asked to pay some fine. So the person is saying he had taken a contract to supply phones which are not supplied, and he has taken some advance also. What is the remedy available to the other person? So what's the remedy available next? You got the issue, na? Mobile phones, 1000 were to be supplied, he supplied 100, then said sorry I can't. The other person can sue him, right? So in which court will he sue the person, and what is the remedy? In civil, he will sue in civil courts, right? And what's the remedy he will get? Some compensation. So he will not be able to get the other person behind bars, but he will say, ki, a court will say, please compensate. Some compensation will be awarded by the courts. So in this particular case, what has happened is a person was drunk driving case. He killed someone coming in a bicycle. He ran away. The person, after killing the other person, ran away, but the CCTV camera in the nearby house captured the act. Yeah, that's the essence. So whether any criminal case can be filed, this person who was killed is an orphan. He doesn't have any relative also. Yeah, the person who was killed is an orphan. He is alone in this world, Lavaris. You have seen the movie of Amitabh Bachchan, Lavaris? नहीं देखी तो देख लेना, ठीक है? So he is a Lavaris. So whether any suit can be filed against this person? And who will file that suit? The state. So if it was happening in West Bengal, it will be state of West Bengal versus Mr. this person, right? And it will go under criminal case. And of course, when he is caught, and when he is apprehended and police will catch hold of him, police will file an FIR charge sheet, and then he will be administered due justice under the old code of criminal procedure, now replaced, and then he will be put behind bars, right? Courts will give their decision. Hi, this is Dr. P. Sanjay, and I am a professor at Indian Institute of Management, IIM in Sirmaur. If you like my videos, please feel free to subscribe to my YouTube channel. Thank you.